Welcome to Senate Federal and State Affairs. We have two orders of business today. First will be a bill hearing on Senate Bill 322, and then we'll start working on final action on House Bill 2086. So let's start off with Senate Bill 322. First of all, I don't think there are any bill introductions, but I might ask if there are. Seeing none, we'll move on. Okay, Senate Bill 322, authorizing any gaming compact regarding sports wagering. We will have Jason, our reviser, give us a quick overview. Jason?
Thank you, Mr. Chairman, members of the committee. Senate Bill 322 amends the statute 46-2305. This statute was enacted last year as part of Senate Bill 84. It authorized sports wagering in the state of Kansas. As part of that bill, this statute was enacted to direct the governor to negotiate in good faith with federally recognized Indian tribes that wanted to negotiate a gaming compact for the tribe to conduct sports wagering. As part of that, subsection B was part of that statute and currently limits the terms of the compact to sports wagering within the boundaries of the tribe's Indian lands. Senate Bill 322 would strike that subsection B in its entirety, so it would just leave it open to the governor to negotiate in good faith with the tribes that were requesting a gaming compact concerning sports wagering, and would allow the tribe to conduct that sports wagering both in person on the Indian lands of the reservation and to accept wagers placed remotely via an interactive sports wagering platform from residents who are located elsewhere in the state, not necessarily on Indian lands. This would go into effect on Kansas Register if enacted, so sooner than July 1st. And with that, Mr. Chairman, I'd be happy to answer any questions.
Thank you, Jason. Committee, any questions on this? Senator Faust-Cadeau.
Thank you, Mr. Chairman. Jason, so leaving that open for the governor to negotiate, would that be indefinite? Would it be situation by situation? Can you elaborate? Thank you.
Sure. So what happens is it basically directs the governor to negotiate in good faith a gaming compact with any tribe that requests to offer sports wagering in the state of Kansas. It would enter into negotiations on gaming compact with each individual tribe one at a time. Those compacts would, when they're agreed upon between the tribe and the governor, they would come back to the legislature and go through the Joint Committee on State Tribal Relations and be subject to ratification by the legislature under the statutes for gaming compacts.
Senator Longmine.
Thank you, Mr. Chairman. Jason, is there anything in this with the expanded, to me this is expanded use than what was in Senate Bill 84. Is there any way that that would violate any of the contracts we currently have with our state-owned casinos?
No, because you're not creating new gaming zones within the state with this. You're just authorizing gaming compacts, which we actually have gaming compacts with the various federally recognized Indian tribes in the state of Kansas.
Any other questions, committee? Seeing none, thank you, Jason. Okay, we will move on to our first oral proponent testimony from Russ Bryan, Counsel for Prairie Band Potawatomi Nation. Russ?
Thank you, Chairman Thompson, members of the committee, for the opportunity to present testimony today. First, I'd like to take a moment to recognize a dignitary, Chairman Joseph Rubnick of the Prairie Band Potawatomi Nations here to observe as well. As this is the first time I've testified before this committee this session, I'd like to take just 2 minutes, if I may, to give you a brief overview of the nation. Nation's government provides the nation's a sovereign, federally recognized Indian tribe. This reservation is located in northeast Kansas. Administrative offices are located near Mayetta, Kansas, north of Topeka. The government provides a wide range of governmental services to the citizenry of the nation, as well as residents of the nation's reservation. Services, run the gamut: housing, education, social services, healthcare, law enforcement, fire protection, road and bridge, other infrastructure, just to name a few. The nation has a casino operator, similar to how the Kansas Lottery has casino operators under contract. Nation owns its gaming. The state of Kansas owns its gaming. the nation has its own casino operator that operates its gaming operations. That operator shares its net revenues with the nation. However, that share is much larger than what the casino operators share with the state. The nation's operator, after it pays its wages, state and federal employment taxes, unemployment insurance compensation to the state of Kansas, various other operating expenses, debt service, they pay 100% of their net revenues to the nation for their governmental services, net of, modest capital improvement reserves. One final note for the nation before I move on to the bill. The nation had a 2020 economic impact analysis conducted showing that the nation and its enterprises employ over 1,100 people directly, more than half of those at its gaming operations. When you look at direct and indirect employment, the vendors, et cetera, the analysis shows that the nation's activities total nearly 3,000 jobs in Kansas, resulting in approximately $24 million in state and local taxes from those jobs. In 2018, the nation had a $177 million impact on the state of Kansas's economy. Now, if I may, I'll just move briefly to the bill. Simply put, as the revisor stated, the bill would strike subsection B of 462305. That provision states specifically, no sports wagering compact will include sports wagering beyond the boundaries of the compacting tribe's Indian lands within the meaning of the Indian Gaming Regulatory Act, which is a federal statute that occupies the field of Indian gaming. This provision, as I just said, references and is tied to the federal statute. The Department of Interior has consistently interpreted the IGRA, as the statute is known, to permit inclusion of statewide remote sports wagering as an appropriate matter for compacting. We note that Kansas specifically, under its laws, permit statewide remote sports wagering. And so, accordingly, under state statute, that is a gaming activity located in a state that permits such gaming for any purpose by any person, organization, or entity. In other words, that is an appropriate topic for compact negotiation, which the state has both a federal and, as a matter of state law, duty to negotiate in good faith over that gaming activity. Based on that, our reading of subsection B is that the legislature did not intend to adopt a statute that could only be interpreted to violate the federal statute. In other words, saying, no, we can never permit any sort of gaming that would be appropriate under IGRA. So when we have read that statute, although, to be honest, we didn't like it when it was in the bill, but we felt it was important to have the state recognize that the state had a duty to negotiate in good faith as a matter of state law. We have always viewed that statute as saying merely no compacting process can really address sports wagering that occurs entirely outside of the nation's reservation. In other words, a wager both placed and received outside of the Indian lands. What we are suggesting is the compact, as other states have done, Florida, Michigan, two examples, wagers placed outside the reservation within the state boundaries, but received on a server on the nation's Indian lands are appropriate and are considered Indian gaming under the federal statute. So that's why we read the statute that way. To do so otherwise would make it inconsistent with federal law and arguably preempted because the Congress has occupied the field of Indian gaming. Again, the nation supports passage of this bill because it removes the impediment to good faith negotiations. The governor's office has struggled with the language because reading it in isolation, it certainly seems clear, but we have to remember that we have the overarching framework of the federal statute as well that applies to this area. Two other points that are relevant to the legislative activity on this front. The only way for Kansas to comply with the federal statute while legislatively taking statewide remote sports wagering off the negotiating table for the tribes is to completely ban that activity throughout the state. In other words, the state would have to just stop taking all remote sports wagers. And that would be the only way under IGRA that they could prevent that from being an appropriate compact topic. If there's ever a conversation about revenue sharing, again, the only way to approve a gaming compact that permits revenue sharing with the state is if the state offers the tribes something that they don't already have a right to do. As we just talked about, it's an appropriate topic to have in a compact. In Kansas, the tribes do, as a last resort, if they have no other options, they do have the opportunity to go get a contract under KELA and proceed that way. However, the only way to actually make that a component of the compact negotiations and ask for revenue sharing is if the state can offer the tribes something they don't have. Typically, the way that has ever come up is if the state offers exclusivity. So yet again, if the state wants the tribes to engage in revenue sharing on those activities, it would have to provide them the exclusive avenue for conducting those activities to comply with federal law. I think I'll withhold the rest of my comments. I don't want to waste your time, but I'm happy to take any questions the committee may have.
Okay, Russ. I think what we'll do, we are going to hear from Will Lawrence, Chief of Staff of Governor,
Right.
And then we'll open up to questions for the proponents.
Absolutely.
Well, you know what? We may just hold for questions till after everyone's testified, and then we can go both directions. I think that'd be better. Thank you, Russ. Up next, we have Will Lawrence, Chief of Staff from Governor Kelly, to make a few comments. Will, welcome to the committee.
Thank you, Mr. Chairman. I'll be brief. I think it's been accurately described. We've been negotiating with Prairie Band Potawatomi Nation for a good chunk of last year and into this year. And the compact, I think it's important to note two things. Once a compact is negotiated and agreed to between the governor and the tribe, that does come back to the legislature for review and approval by joint resolution. So I think that's also important to keep in mind when we're talking about what should or should not be in a compact. Subsection B is the focus of this, and that, of course, has been a barrier. This does not in any way, shape, or form expand gaming in Kansas that's not already authorized. This allows for us to continue to have conversations with Chairman Rupnick to try to reach an agreement on the compact. And there are, of course, some federal issues at play that we have to consider. But the big challenge for us is when you read subsection B in isolation, it is very clear. And that is a challenge that we've had in the governor's office and in the attorney general's office in talking through this. And so we need to remove this so that we can move forward with those conversations. It's very simple. Don't believe that it does anything other than allow us to continue those conversations. And I'm happy to stay in for any questions.
Okay, thank you, Will. There are no neutral opponents or no neutral testimony on this. We do have oral opponent testimony. First from Whitney Dameron on behalf of Kansas Entertainment, LLC. Whitney.
Thank you, Mr. Chairman, members of the committee. Whitney Dameron, Kansas Entertainment, LLC, the owner-operator of Hollywood Casino at Kansas Speedway. We were involved, obviously, with the sports wagering bill, Senate Bill 84, in 2022. We had discussions with representatives of the Prairie Band Potawatomi Nation and as they were very much engaged in the discussion of this bill. The language that you have before you to be struck was not the casino manager's language, that's their language. I can tell you from my client's standpoint, I would say kind of at the 30,000 foot level, we were okay with the tribes, 4 resident tribes in Kansas, being able to engage in sports wagering, negotiate a compact with the state of Kansas on reservation, conduct sports wagering as they deem appropriate on reservation and off reservation as the casino managers do through an app on a level playing field with the 4 casino managers in the state. What is being talked about, what is being proposed is not a level playing field, and we've enumerated some of that in our testimony, but first and foremost is the 10% tax on the hold that the casino managers pay, have to remit to the state of Kansas. No such obligation on behalf of the tribe, and you've heard testimony today that they don't believe that would be appropriate. From memory, I believe all 4 gaming compacts that the tribes have in Kansas specifically prohibit them from engaging in sports wagering. It would seem to us, it seemed to me that entering into a compact to allow sports wagering off reservation through a mobile app would be adequate consideration for the imposition of some kind of a tax or a fee, whatever they want to call it, that would put them on a level playing field with the other casino managers. We also have concerns about whether they're going to operate under the same rules of the road that we do, whether they're restricted to the same kinds of bets, same kind of a regulatory framework, whether it's through racing and gaming or through tribal regulatory process. That potentially creates uneven playing field and also confusion for the bettor within the confines of the state of Kansas. We understand there is an urgency for the bill. Unfortunate that it came about so late in the process. We've had conversations with representatives of the tribe. We've agreed to have a conversation about this and see if we can come to some kind of an accommodation that we believe keeps everyone on a level playing field, which is what we agreed to do in 2022. But until such a time, we think that we ought to hold off on this bill at least for the next 24 hours or so and see if those conversations can be held. With that, Mr. Chairman, I'm available for questions whenever.
Thank you, Whitney. Appreciate it. Up next, Kevin Fowler on behalf of Kansas Crossing Casino and Kansas Star Casino. Kevin?
Thank you, Mr. Chairman, members of the committee. My name is Kevin Fowler. I'm a Topeka attorney with the law firm of Frieden and Forbes. I've been through this before this committee many times on the subject of sports wagering. In fact, sports wagering is a long time coming in Kansas. During the past 5 legislative sessions, this and other committees have had hearings on sports wagering. And last session, we finally reached an agreement among all of the interested stakeholders in Senate Bill 84 that was passed just last year. I'm appearing today on behalf of 2 of those stakeholders, the managers of the Kansas Crossing Casino in Pittsburgh, Kansas, and Kansas Star, which is located in Mulvane. We are opposed to this bill for a couple of very practical reasons that are set out in my written testimony, which I'm not going to read for you. But those 3 reasons are it's unnecessary. In fact, it's curious. The predecessor of Senate Bill 84 was House Bill 2740, which originated in the House Federal and State Affairs Committee when John Barker was the chairman. It was his bill. And in fact, there are 2 provisions in 2740, and that is Section 13 and Section 17 of House Bill 2740 that found their way into Senate Bill 84 as Section 14 and Section 18. Now, the reason I'm giving you this background is because Mr. Bryan submitted testimony on House Bill 2740 that includes the provision that this bill, Senate Bill 322, seeks to repeal. And the testimony that he submitted before the House on that very issue last year supported the provision. It supported the provision. That was part of the bargain struck by all of the interested stakeholders. And now they want to change the rules of the game after the 4 state casino managers have invested hundreds of thousands of dollars to roll out their sports wagering programs on a statewide basis. And they have the audacity to say, we're only willing to accede to Section 14, which, by the way, is the provision that says if they want to do statewide sports gaming, negotiate an agreement with the lottery. You don't even need a compact. You just need to be seeking a compact, and then you're entitled to enter into a sports wagering management agreement with the lottery on the same terms and conditions as our casino managers are obligated to follow. They want a better deal. In fact, they said the only way we'd consider that is if you did not have any of your own state-owned and operated sports wagering through casino managers. We want an exclusive. So jettison your contracts with your state casino managers that have been in business for quite a long time on gaming issues generally, and since September of last year on sports wagering. Under the Kansas Constitution, which sets our policy on gaming, it is illegal for anyone other than the state of Kansas to conduct sports wagering within the jurisdictional boundaries of this state. And so what this legislation essentially proposes is something that would be illegal. Under the Kansas Constitution, unless sports wagering is owned and operated by the state, it is illegal. And they are proposing authority from the legislature to engage in statewide sports wagering that is not owned and operated by the state. Now, it may well be that under the Indian Gaming Regulatory Act, it's okay for a state, if it chooses, to negotiate as part of a compact authority to go beyond Indian lands. And the reason for that's simple. You can always negotiate to give somebody something more than they're entitled to receive. But as a matter of federal law, the Indian Gaming Regulatory Act is expressly limited to the boundaries of Indian lands. Now, that's why we have the boundary limitation in Kansas law. It recognizes two things. The federal act is limited to the boundaries of Indian lands, and the Kansas Constitution basically says if you're going to offer gaming outside of the boundaries of Indian lands, it has to be state-owned and operated or it's illegal. That's why Senate Bill 84 includes the provisions that it does. It provides a fair and balanced playing field for all interested stakeholders, including the tribes, if they want to offer sports wagering off reservation lands. That I could go on for quite a lot longer, but
Probably wrap it up here real
that
fast.
pretty much wraps up my pitch, and I would urge you to give this bill unfavorable consideration because it really will disrupt the landscape, embroil the state in unnecessary litigation, and it's inconsistent with long-standing state policy, and it would be unconstitutional to boot. Thank you so much.
Thank you, Kevin. Up, our final oral opponent is Chris Reedy. And Chris, if we could confine it to anything that hasn't already been, any ground that hasn't been covered, I'd appreciate it. Thank you, sir.
Thank you, Chairman, members of the committee. Appreciate this opportunity to give some opposition testimony. I think it's real important to look back that the legislature has always given the tribes an opportunity to be on level playing ground with the casino, with who eventually became the casino managers. As you've heard already, this is the same situation. Last year, they had the opportunity. By going beyond this, I think that the lines crossed. They're Indian lands versus the state-owned lands, and that has to be, in our mind, kept separate. The state cannot tax anything that's done by the Indians through these compacts. That's a fact, and I think the Chief of Staff appropriately noted that, unless there's something given for services. Right now, the stage has been set in the marketplace. The state gets 10% revenue on this, and that shouldn't be changed. The other thing is factors such as problem gaming, all the advertising and things of that nature, that's highly regulated by the Racing and Gaming Commission now. I think that goes significantly at risk by the changing this law and allowing it to be covered by compact. The state loses regulatory authority. So with that, and adopting all the other comments I've made, I'd urge you to reject the bill. Thank you very much.
Thank you very much, Chris. Okay, committee, there's no additional testimony. If there's anyone else who needs to speak to this, seeing none, committee will open for questions for either proponents or opponents of this bill. Senator Holscher.
Thank you, Mr. Chair. Thank you all for being here. I was just wondering if we could have Will maybe expound upon or respond to some of the comments that were made.
Sure. Will?
Thank you, Mr. Chairman, and thank you, Senator. You know, I think that the opposition testimony is kind of jumped to some conclusions here. Everything that's being discussed would be the subject of discussions on a compact. The whole discussion about statewide versus on tribal lands is a subject that has to be discussed and has to be agreed to in a compact. I don't really understand Mr. Fowler's comments. Senate 84 was a bill passed by the legislature and signed by the governor. I don't think that Mr. Fowler was part of any agreements on the bill, and I feel like most of his commentary doesn't make a whole lot of sense and jumps to a lot of conclusions. There is a long ways to go with Prairie Band Potawatomi Nation on this. There's federal law involved that we'll have to wait to find out what the decision is, or probably go to the U.S. Supreme Court. So ultimately, this is jumping the gun on some stuff that I just don't think that they honestly have a lot of business being involved in. This is a compact between the state and the tribal nations in Kansas. And right now, that's all this is about, is to strike you one provision to allow conversations to move forward, not do anything else. Thank you.
Senator Fasquedo, then Senator Longmire.
Thank you, Mr. Chairman. My question, too, is for Will Lawrence. As you're coming forward, I just want to make sure that Russ, the council that for Prairie Band that spoke, are they okay with the word Indian and not Native American?
I would defer that question to the chairman.
Okay, well then let me just go on with the question for you, Will. So in the information that we have received here, it talks about the federal law, and it talks about that if, in fact, Indian/Native American Council asked to have the discussion with the governor, that the governor must recognize. Can you just expound a little bit on that legal procedure? Thank you.
Sure. So Prairie Band and Potawatomi Nation made the request to negotiate. I can't remember the date, but last year, shortly around the time of Senate 84 passing. And so we began negotiations on that portion of their compact because, as referenced, there is a provision that prohibits sports wagering within the compact. So now that needs to be changed. And so we've entered into some very limited discussions related to sports wagering that would involve sports wagering in person on the tribal lands, and then discussions about how remote wagering might work. And the remote wagering component of this and the other provisions of Senate 84 related to the lottery have led us to this juncture in talking about striking a subsection B. The other opportunity is to continue to push back on subsection B, go to court to get an answer on if it's preempted or not, which I think we can avoid here because it probably is preempted. And then we end up pushing them to try to go through the lottery. So we want to ask a sovereign nation to waive sovereign immunity and give us ownership of their sports wagering operation, because as Mr. Fowler said, to do otherwise would be unconstitutional. So that's why we are where we are today.
Follow up. Thank you, Mr. Chairman. Just real quick. So then, in fact, the governor is doing what the Fed says she must do, and you think this legislation would fix that issue?
Correct. Yes, we are working to negotiate in good faith. There's a barrier right now on this language, and it needs to be addressed, and this addresses that so we can move forward.
Thank you.
Senator Longmire.
Thank you, Mr. Chairman. Will, sorry. I guess I'm going to jump on the Fowler bandwagon and say that I was a negotiator at the table also on this bill for maybe 5 or 6 years or whatever it was. I distinctly remember representatives of the Indian gaming people asking for this legislation and testified for it. So evidently circumstances have changed. Can you tell me what those circumstances are?
Sure, Senator. I don't think circumstances have actually changed. I think that there's a difference of opinion on the view of that language. And Mr. Brien really kind of laid that out in terms of when you read that in conjunction with IGRA, you get to one conclusion. The problem that we have is you get to the state law portion and it is clear. And so, but if we take the interpretation that is very clear we're probably going to run afoul of IGRA. And so that is, we have a situation where your statutes are conflicting. Federal law is going to win on that, so we can go get the answer in federal court, or we can answer it here because it's going to be the same conclusion, is where we are.
Senator Peterson.
Thank you, Mr. Chairman. Will, it's probably for you too. You talked about what you're asking is them to give up their sovereignty as far as the ownership of the sports gaming. So then they would be subject to the 10% tax and the regulations on advertising and the 2% to the problem gaming fund.
Senator, so we're having all those conversations, and I think on the regulations as it relates to like not betting on high school sports and who's prohibited and that type of stuff, those are all things that can be put in the compact. I mean, honestly, most of the stuff being talked about now, we can and already are addressing in the compact. The 10% revenue share is an issue and one that is a real challenge to address. But let's be clear, Symbol 84 always contemplated that there would be sports wagering on tribal lands that would not be subject to the 10% tax. So where the casinos are jumping out on right now is the 10% tax for anything off of reservation land or off of Indian lands. And so we're not there yet. We're not even having those conversations yet. We're probably waiting for a case referred to as a Seminole case out of Florida to have a final decision before we even know if that's possible or not. If the Seminole case says that you can accept wagers on tribal lands on a server, even if the person accessing it is off of tribal lands, then they can do it now anyways. If they come down and say you can't do that, that's not an appropriate interpretation of the law, then they can't, and it's over. But this language is a barrier to us even talking about that stuff right now, and that's what we're trying to address so we can move that forward.
Any other questions? Seeing none, thank you, Will. Committee, we're going to allow you time to digest all the testimony here, so we will close the hearing on Senate Bill 322 and see what kind of progress can be made on this. And if we have to revisit it, we certainly will. Next up, we're going to move on to final action on House Bill 2086. Committee, is there anyone who needs a refresher from Jason on the 2086? Senator Straub would like a very quick refresher on House Bill 2086. Top 20. We'll keep it terse. Jason, I'll let you go ahead.
Mr. Chairman, members of the committee, House Bill 2086 is the bill brought by the Secretary of State's office to clarify duties and qualifications of election officials, to clean up obsolete or conflicting provisions within the statutes, and to make other statutory amendments addressing issues that have arisen in recent election cycles. If the committee has questions about any particular provisions, I'd be happy to go through those, but to hit all the different provisions would probably take the rest of the committee's time.
Okay.
So it's up to you, Mr. Chairman.
All righty. Senator, do you have any questions?
Thank you, Mr. Chair. You made my point. Exactly. Thank you.
Okay. Any other questions for Jason? Seeing none, thank you, committee. I think we've got a number of amendments coming up. So we should probably, and by the way, we have been working diligently with both sides on this bill to try to come to a good agreement. And there are a number of amendments here, so we're going to just start plowing through those and see where we can get. So we'll start, I guess, Jason, I'll let you, I believe, reviser's choice on which amendment we start with. Oh, okay. These are the presidential preference primary statutes that we're striking from House Bill 2086. We'll pass that out and let, once everyone has a chance to look at it, let Jason go ahead and explain the intent of this amendment.
Yes, Mr. Chairman, members of the committee, if you recall, Senate Bill 321 that this committee heard and worked just last week made various amendments to statutes governing a presidential preference primary election. House Bill 2086, when it was originally drafted, was going to straight repeal those statutes. And since this committee had already decided to amend them instead in that bill, then this amendment strips out those statutes so they would not be repealed by 2086. So you can see the changes on page 1 of the bill in lines 13 and 14, and on page 54 of the bill in line 37.
Okay. Committee, any questions? Seeing Senator Blasey.
Thank you, Mr. Chairman. So how does this amendment then affect, if at all, Section 13? Trying to find a page here. It's a big bill. Section 13, we're striking B in the year 1992 of the boundary. It talks about presidential primary elections. Is that election just, as I assume that language is just pertaining to the actual 92 election and not the rest of the statute?
What page is that on?
That's page 9, I believe.
Page 9.
Wait, 9,
Okay.
7 and 8.
Line 7 and 8. That'd be section 15. Oh, page 7 and 8, I'm sorry.
I don't believe it would have any impact on Section 13. Section 13 deals with primary elections held in August and even-numbered years, and does not, I don't see a reference to a presidential preference primary on Section 13 on pages 7 and 8 of 2086.
Section, so primary national? I guess that's just national offices. All right, sectional 24 talks about presidential preference primary elections on ballot printing. Is that, what's the correlation with that statute?
That statute provides county election officers shall have charge of the printing of ballots for all elections, primary, special, and general, which would include the presidential preference primary elections. The language being struck in there directs that the Secretary of State may provide for the printing of all or portion of the ballots of a presidential preference primary election. I believe that is still allowable under the presidential preference primary statutes that the Secretary of State could. In any event, the Secretary is directed to reimburse county election officers for costs of conducting the election, the direct costs under the presidential preference primary election statutes. I can't remember exactly which of those statutes it is, but the Secretary of State is directed to reimburse the cost of printing. So if the county election officer is printing the presidential preference primary election ballots, they can submit those costs to the Secretary of State and get reimbursed for those costs.
Okay, so there's really no correlation then with this repeal of statutes that we're striking on the amendment?
No.
Okay.
Any other questions? Seeing none, is there a motion on this amendment? Okay, we have a motion by Senator Longmire to pass this amendment favorably. Do we have a second? Second by Senator Peterson. Any discussion? Senator Holscher.
Just for excuse me, just for clarification, is this one of the amendments that were agreed upon between the negotiated parties?
It was. Well, this was, take that back. This was, we sat down and we looked at the, well, in a way it was. We looked at the number of objections that we got from the opposing side, and these amendments were offered by the Secretary of State as a compromise to this bill to try to help clean up those concerns. So yes, this is these 8 amendments are actually as a result of working with both sides on this issue. Okay. Okay, we have a motion and a second. Any discussion? All those in favor say aye. Aye. All those opposed, no. The motion carries. We are back on the base bill and move on to the next amendment. We're working Jason pretty hard today. Oh. Okay. I will, we'll pass this out. This is dealing with giving the judges control at the polling place. And we'll let Jason explain that amendment.
Mr. Chairman, members of the committee, this balloon would strike Section 41 of the bill in its entirety. That section was amending a statute to provide that judges, supervising judges, could expand the distance beyond 3 feet at polling places, and this is the distance between the voting booths, voting machines, or tables being used by election board. And so there would be no authority to expand that distance by supervising judges under this balloon because that amendment would be stricken. You can see it on page 33 of the bill.
Okay. Committee questions? Senator Blasey?
Thank you, Mr. Chairman. I will offer this amendment, I guess, because I do believe we shouldn't give judges that much discretion. I mean, as needed is so vague on line 34. I just don't think it's necessary unless obviously observers are being disruptive to the process. So I will move this amendment.
Okay. Do we have a second? Second by Senator Longmire. Any discussion or questions? Senator Fausto.
Thank you, Mr. Chairman. So, Jason, polling judges already have the authorization, and that's why they are the judge in charge of the other poll workers. And polling judges usually have a little bit more training and understanding of perhaps that voting location. So just because it's what this amendment kind of seems contradictory to me, because I heard the same thing twice, but in a different way. So can you clarify? So are we taking the power and the control of that polling judge to not be able, are we taking their duties away from them?
Jason.
Mr. Chairman, members of the committee, this amendment simply retains current law with respect to supervising judges' authority with respect to the polling place and how close individuals can get to the voting machines and election tables, which is 3 feet under current law.
Okay, thank you for that clarification.
Any other questions? Seeing none, we have a motion and a second on this amendment. All those in favor say aye. All those opposed, no. Motion carries. Back on the bill, and the third amendment coming our way. This amendment strikes a section that designates who can designate polling agents. We'll pass it out and have Jason explain this amendment.
Yes, Mr. Chairman, this balloon would strike Section 50 of the bill in its entirety, and this statute directs who is an authorized poll agent. Under the bill, the language was striking precinct committeemen and precinct committee woman and chairperson of a state party committee as individuals who could be authorized poll agents. There's also striking committee men and committee women under appointments of authorized poll agents. And so those amendments would not be part of the bill under this. It would simply retain current law with respect to authorized poll agents if this balloon is adopted.
Hey, committee, any questions or discussion? Seeing none, do we have a motion on the amendment? We have a motion by Senator Blasey. Is there a second? Second by Senator Straub. Any further discussion? Seeing none, we have a motion and a second. All those in favor say aye. All those opposed, no. The motion carries. The amendment has passed. We're on to the base bill again and the fourth amendment. Amendment regarding hard drives and backups. And we'll pass it out and let Jason explain this.
Mr. Chairman, members of the committee, this balloon amends new section 3 of the bill. This was a section that prohibits any county election office or employee or agent to create or permit any other person to create any image of a hard drive of any electronic or electromechanical voting system, optical scanning equipment, or any other voting system that has a hard drive component without the written consent of the Secretary of State. The amendment appears on page 2 of the bill and would add a new subsection that creates an exception to this that would direct each county election officer to create a backup copy of any hard drive of such systems. And those backups would have to be created prior to and immediately after any system updates, repairs, or improvements, and prior to and after each general election. And the backup copies would have to be maintained in a secured location for not less than 22 months.
And of course, this is would allow for comparison between the backups so that we can find if there's any malware, any kind of hidden type software to create problems with the process. Committee, any discussion on this? Senator Straub. Oh, Senator Falscadeau. Senator Falscadeau. Sorry about that.
Thank you, Mr. Chairman. Jason, so is this on just the elections, the machines that are used there, or just everything, even in the election office and just their normal duties?
Mr. Chairman, it would be hard drives with any electronic or electromechanical voting system, the optical scanning equipment, or any other voting system. So we're talking about the election equipment that has a hard drive component.
Okay. Senator Straub.
Thank you, Mr. Chair. Jason, our current law doesn't require that counties have paper ballots. We have some counties that may have strictly electronic voting systems, correct?
I believe there's a paper ballot requirement, but I'm going to defer to Mr. Caskey to clarify that point.
Senator, in Kansas, every county has what's called a ballot marking device that produces a paper ballot. Separate from that, every county has paper ballots available, so the voter, if they do not want to use the ballot marking device, can use just a plain piece of paper, not a plain piece of paper, but a paper ballot. So both the machines produce a paper ballot, and separately, we have just standalone paper ballots in every single county, at every single polling place.
May I follow up?
Sure.
So this would prohibit our elected election officers from making a copy of the hard drive, even if our election officer suspects that there may be an error, I mean, even an honest error in the hard drive of that voting equipment?
Mr. Chairman, this amendment would require each county election officer to create a copy of the hard drive at certain times. It would be before and after system updates or repairs, and before and after any general election. They would be required to make a backup copy and then secure that backup copy for at least 22 months.
Okay. And only the election officer?
Only the county election officer would be able to do that, yes.
So no outside auditing firm would have access to?
No, the general prescription against making a copy or another image of the hard drive by any other person would still be in place.
So in other words, somebody couldn't just come up and ask for a backup to do a backup. It would be prescribed to the election officer only. Any other questions? Seeing none, is there a motion? Senator Longbine makes a motion. Is there a second? Second on the amendment. Second by Senator Straub. Any further discussion? Seeing none, all those in favor say aye. All those opposed, no. That passes, and we are back on the base bill and on to amendment number 5. This will be the consultation on the HAVA complaints with the Attorney General. Once it passed out, we'll let Jason explain this amendment.
Mr. Chairman, members of the committee, this amendment would amend Section 66 of the bill. Under the bill as written, if there is a complaint filed under the Help America Vote Act with the Secretary of State, there's new language proposed by the bill that would allow the Secretary of State to dismiss the complaint without a hearing if the complaint fails to allege facts that assert a violation of that federal law. What the balloon would do would direct the Secretary of State to consult with the Attorney General on such complaint before dismissing it without a hearing. So there would be an opportunity to review it with the state's Attorney General.
Committee, any questions? Senator Faust-Godot.
Thank you, Mr. Chairman. So the only process, are you saying, Jason, would be, so kind of give me the scenario. So someone on the local level makes a complaint to the election commissioner who then makes it to the Secretary of State's office, who then consults with the Attorney General's office on that complaint, as opposed to just dismissing it.
I believe you summed it up fairly well, Senator. Yes, the complaint would be filed with the Secretary of State's office. Under the proposed language, the Secretary could dismiss that complaint without conducting a hearing on the complaint, but under the proposed balloon, the Secretary must first consult with the Attorney General on the complaint before ordering such dismissal.
So is this a complaint that came directly from the election commissioner locally, or are they, that election commissioner, involved in that situation?
I believe the complaints can be received from any member of the public, not just election officers.
I'm going to bring Clay Barker up for any clarification too. It looks like he might have some additional comments on this.
Thank you, Senators, members of the committee. This complaint gets confused sometimes. This was part of the original Help America Vote Act, which was enacted, I believe, 2004. And it was a way for citizens, members of the community, to bring a complaint to force counties or the state to implement the Help America Vote Act. Kansas did that by 2006. So the reason for these, it's a very narrow band of subjects that can be subject to this complaint. And the concern we had is the way the language is written, no matter what the complaint is, it would seem to say we have to hold a full-blown hearing with lawyers and scribes. The last two complaints we received over the last 2 years, one was a notary public complaint that has nothing to do with elections, and the other one was one Mr. Caskey and I got last week, where someone was complaining that a election training someone wore smelly perfume. And that's the kind of subject we get now. We just wanted to protect ourselves from someone saying, hey, I don't care what my complaint was, I need a full-blown hearing. We are perfectly fine with running those past the Attorney General to check off. That's what this, we aren't trying to keep the public from complaining. We listen to Senator complaints all the time. This is just a very narrow administrative complaint process.
Any other questions, committee? And I think any complaints about wearing high karate would also be in order. My granny used to buy me a gallon of that stuff for Christmas every year. It was terrible. Okay, any further questions or discussion? Seeing none, do I have a motion on this amendment? Motion by Senator Longbine. Do I have a second? Second by Senator Blasey. Any further discussion? Seeing none, all those in favor say aye. All those opposed, no. Motion passes. Back on the base bill and moving on to amendment number 6. We're running out of time. We've only got about 5 or 6 minutes so we can get everybody to caucus, and we may have to pick this up again at a later time. This strikes the ability to challenge the election of a committee person, and I'll let Jason explain that.
Mr. Chairman, members of the committee, this balloon amends Section 58 of the bill on page 47. This is a statute dealing with the election of precinct committee men and committee women. As part of the new language, lines 14 through 17 of that would allow the chairperson of the state or county political party to file an objection with the county election office or at any time to challenge the eligibility of a person to be a candidate for a precinct committee man or committee woman. That ability to object to the eligibility of the candidate is being stricken there in lines 14 through 17. The remainder of the provisions of that statute are simply clearing up when they take office and to allow or to require the precinct committee men and committee women to provide their contact information so they can be contacted when the committee is called.
Thank you, Jason. Committee, any questions? Senator Fausto.
Thank you, Mr. Chairman and Jason. So this striking of the original language in the bill prior to the striking, so was that saying that the Republican Party could object to the Democratic precinct person, or is it just within those political parties of rejection?
I believe it was the same political party, but I'm going to defer to the Secretary of State's office if they could provide clarification.
Clay, if you'd like to come up.
Senator, first of all, we completely agree with this amendment. There was I don't know how it happened, but issues in several counties last elections where people were elected as a precinct leader who were not affiliated with that party. And we had county chairs, county election officers, and some House reps complain about that. And we put a few provisions in to prevent that. This was one of them. We're fine with getting rid of it. It may cause confusion. There was no one who could actually object to an improperly elected precinct leader. But again, there's other provisions to prevent this. We're fine with this amendment.
All righty. Committee, any other questions or discussion? Seeing none, do I have a motion on this particular amendment? Motion by Senator Blasey. Do I have a second? Second by Senator Reichman. Any further discussion? Seeing none, all those in favor say aye. All those opposed, no. That amendment carries. We've got about 3 more minutes. Let's see if we can get one more amendment in here before we, we'll probably have to adjourn and then see whether or not the Senate President allows for another committee meeting, but we'll get as far as we can get here. This is on write-in affidavits. This is amendment number 7. We'll pass it out and let the reviser, Jason, give us a quick brief on that.
Yes, Mr. Chairman, this balloon would strike Section 19 of the bill in its entirety. This statute directs that to be a write-in candidate for certain offices, you have to file a affidavit of write-in candidacy, and it was cleaning up the time for when those affidavits had to be filed with the Secretary of State's office. If you recall, this committee did work out Senate Bill 221 and pass out a committee which did not only address the issues of when those affidavits have to be filed, but also expanded and required affidavits of write-in candidacy for county elected offices and elected offices for cities of the first class. And so this is just removing it from the bill here.
Got it. Committee, any questions or discussion? Senator Holscher.
Thank you, Mr. Chair. Just for clarification, so we're talking about timing of affidavits only in regard to write-in candidates. Did I hear that correctly or understand that?
That's correct.
Any other questions? Senator Longmire? Senator Longmire has a motion, second by Senator Blasey. Any further discussion? Seeing none, all those in favor say aye. All those opposed, no. Committee, we are out of time, so we can get to caucus at 1:30. We'll see where we go from here, but with that, we are adjourned, and thank you for your hard work today.